In other words, things that if you say it that way, it's clear that they would fall under executive privilege. But how does that relate to the question that we're asking here?
So this is one of the most difficult questions for the Department of Justice. And I want to explain why that is. If we are operating under a Fitzgerald versus Nixon lens and looking at this the way that we look at things when there is a private lawsuit filed against the president, we take a very broad view of what the outer perimeter of official presidential action is in order to be as protective of the president against private lawsuits that, as this court explained in Nixon versus Fitzgerald, can be very deleterious to the president's conduct of business. So if we were putting this under a Fitzgerald lens, we would then have to answer to the question, was he acting in the capacity as office seeker, or was he acting in the capacity as office holder? And if you run through the indictment, you can find support for those two characterizations. And the Department of Justice has not yet had to come to grips with how we would analyze that set of interactions.
Thank you.
Justice Gorsuch?
If you did, though, I just wanted to confirm, I thought I heard you thought that the blazing game framework was the appropriate one. Is that right?
Largely, yes, Justice Gorsuch. We agree with the idea of the distinction between office holder and office seeker. We also agree that if it's objectively reasonable to view the activities as those of office holder, then the Fitzgerald immunity kicks in. I think we would look more at the content of the actual interaction in order to make that determination than Blasingame suggested, at least on the facts of that case, might be appropriate.
Can you give me an example of what you have in mind? I'm just trying to understand what nuance you're suggesting.
So Blasingame adopted a generally very favorable pro-government framework that we endorse in private civil cases. Yeah. Okay, not here, because we don't think that Fitzgerald applies in the criminal context.
No, I understand that, okay. but putting that aside, the distinction between official act and private office seeker.
Yes.
Their test is, you think, good enough for government work?
On this one, the department hasn't taken a next step since the Blasingame decision, but let me offer a few thoughts that Justice Gorsuch I think might clarify it. The Blasingame decision focused on objective contextual indications to try to see whether the president was acting as a campaigner as opposed to an office holder. Yeah. I think that decision can also be made by looking at what the president actually said. And let me illustrate that with an allegation that I think my friend talked briefly. In one of the interactions between petitioner and a state official, petitioner is alleged to have said, all I needed you to do is to find me 11,000 votes and change. I think if you look at that content, it's pretty clear that petitioner is acting in the capacity as office seeker, not as president, and we would look at that content.
Okay. But the test, I'm just focused on the legal test.
Correct.
I'm not hearing any objections to it.
Other than I think that the D.C. Circuit placed more content consideration off limits than I would.
Okay. All right. And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably. Do we look at the motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected as such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in re-election.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers?
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of motive.
That's right.
Okay.
That is right.
All right, so then we're in the non-core powers,
right,
where we're fighting over. What role do motives play there? I mean, one could remove an appointee that, well, first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court in cases like Myers and Seal of Law has regarded as having a constitutional status of being removable at will from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And a restriction,
put that aside. Yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes, to enrich yourself, for example.
Well, bribery, all right, yes. but that's what I was wondering. Do motives come into the core power analysis or not? And now I'm hearing, I thought I heard no, and now I'm hearing maybe.
I think maybe might be a little bit more appropriate because it's not involved in this case. The department has not had to take a position on exactly how these core powers would be resolved under an as-applied constitutional analysis. None is involved in this case.
And I guess I'm wondering, and I'm not concerned about this case so much as future ones too, but these non-core powers and maybe core powers where a president is acting with at least in part a personal interest in getting reelected. Everything he does, he wants to get reelected. And if you're allowing in motive to color that, I'm wondering how much is left of either the core or non-core powers.
So I would be fine with carving that out and deeming that to be something that's intrinsic in our electoral system. We're not talking about applying criminal law to somebody who makes an announcement that this program will be good for the United States, and somebody could come along and say, well, you really did it to get reelected. Leaving aside whether any of that violates a criminal law, I know that the next question is assume that it does. I'm doubtful that it in fact does, because I don't think criminal laws generally operate on motives as opposed to objectives and purposes. But
all right, intentions. I mean, you can frame a motive as an intention, and intention as a motive, as you well know, every day of the week.
Yes.
So let's put that aside, too.
I understand. Well, putting that aside, that really, to me, falls in a very different category, and it is also possible.
So there's some motives or intents that are cognizable and others that aren't. I mean, it's awkward, right, when we look back at like the injunction, back to Marbury in the early cases. You can't enjoin a president.
Yeah.
Also, you couldn't hold him in contempt. Right?
A sitting president.
For sure.
Just, can I try one more time?
Well, let me just spin this out just a second, right? And it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, Nixon versus Fitzgerald, that's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's re-election or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other limits, reactions, thoughts.
Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I don't normally say, which is that's really not involved in this case. We don't have bad political motive in that sense.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the ages.
Yes, and I think I would start by looking at the statutes and then seeing what restrictions they do place on the president's conduct. And, for example, the statute that prohibits fraud to defeat the lawful functions of the United States. The statute defines what the purpose is that the defendant has to have in mind. It has to be to defeat something that the United States is doing, and it has to be by deception. I don't think that that gets us into the realm of motive hunting in the area where we are as concerned, I think, as the court would be about doing something that would undermine the presidency and the executive branch. And 1512C2, we may have different views on the clarity and the scope of that statute. I think if the court does interpret corruptly as involving a consciousness of wrongdoing and elevates that to consciousness of illegality, then we're in a different realm. Wanting to get reelected is not an illegal motive, and you don't have to worry about prosecuting presidents for that.
Yeah. Okay. Thank you, Mr. Dreeben.
Justice Kavanaugh?
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution as the questions of the court.
So it's the Solicitor General?
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. I'm very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. Mm-hmm. I think that was a terrible decision for the presidency and for the country, and not because there were bad people who were independent counsels, but President Reagan's administration, President Bush's administration, President Clinton's administration were really hampered,
yes,
in their view, mm-hmm, all three, by the independent counsel structure. And what I'm worried about here is that was kind of, let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president. Usually was how it worked. And Justice Scalia wrote that the fairness of a process must be adjudged on the basis of what it permits to happen, mm-hmm, not what it produced in a particular case. You've emphasized many times regularity of the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by the statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? To be sure, the investigation must relate to the area of criminal offense specified by the statute, but that has often been, and nothing prevents it from being very broad. I paraphrased at the end because it was referring to the judges.
Yes.
That's the concern going forward, is that the system will, when former presidents are subject to prosecution, and the history of Morrison versus Olson tells us it's not going to stop. It's going to cycle back and be used against the current president or the next president and the next president and the next president after that. All that, I want you to try to allay that concern. Why is this not Morrison v. Olson redux if we agree with you?
Well, first of all, the independent counsel regime did have many structural features that emphasized independence at the expense of accountability. We don't have that regime now, but even under that regime, Justice Kavanaugh, I think if you look at Lawrence Walsh's report on Iran-Contra, I think this goes to a very fundamental point for the court to consider. Judge Walsh said, I investigated these matters. the proof did not nearly come close to establishing criminal violations. So we've lived from Watergate through the present, through the independent counsel era with all of its flaws, without these prosecutions having gone off on a runaway train.
I think President Reagan, President Bush, and President Clinton, whether rightly or wrongly, thought contrary to what you just said.
I think nobody likes being investigated for a crime, but it didn't result in the kind of vindictive prosecutions that I think Your Honor is raising as a possibility.
Yeah.
We have a different system now. I think there was a consensus throughout Washington that there were flaws in the independent counsel system. It lapsed. We now are inside the Justice Department with full accountability resting with the Attorney General. So the special counsel regulations now don't operate the way that the independent counsel regulations do. And this court would have something to say about it, I think, if the independent counsel statute were revived. I'm not sure that anybody is in favor of that.
Right. No, I was just saying this is kind of the mirror image of that is one way someone could perceive it. But I take your point about the different structural protections internally. And like Justice Scalia said, I do not mean to suggest anything of the sort in the present case. I'm not talking about the present case, so I'm talking about the future. Second, another point, you said, talked about the criminal statutes. It's very easy to characterize presidential actions as false or misleading under vague statutes. So President Lyndon Johnson, statements about the Vietnam War. Say something's false. Turns out to be false that he says about the Vietnam War. 371 prosecution after he leaves office?
I think not, but this is an area that I do think that merits some serious and nuanced consideration. Statements that are made by a president to the public are not really coming within the realm of criminal statutes. They've never been prosecuted. I realize that the court can say, well, what if they were? And then I think you get to what I would regard as a hard constitutional question that would probably guide the court away from trying to resolve today, although I do think it's very different from our case and distinguishable in important ways. But you're dealing here with two branches of government that have a paramount interest in the integrity and freedom of their interactions with each other. On the one hand, the president, of course, should be very free to send usually his cabinet officials and sub-cabinet officials to testify to Congress, to provide them with the information needed to enact legislation and to make national policy. And we're very concerned about anything that would trammel that. On the other side of the equation, Congress has a compelling interest in receiving accurate information, and at the very least, not information that is intentionally and knowingly false. Right. That would pollute the legislative process.
How about, I think it came up before, President Ford's pardon. Very controversial in the moment.
Yes.
Hugely unpopular, probably why he lost in 76.
Yes.
Now looked upon as one of the better decisions in presidential history, I think, by most people. If he's thinking about, well, if I grant this pardon to Richard Nixon, could I be investigated myself for obstruction of justice on the theory that I'm interfering with the investigation of Richard Nixon?
So this would fall into that small core area that I mentioned to Justice Kagan and Justice Gorsuch of